United States v. Allen, 1997 10th Circuit. Allen appeals his adjudication of juvenile delinquency in the United States District Court for the District Court of New Mexico in a non-jury trial held on September 11th, 12th, and 16th of 1996. The District Court adjudged Allen J. a juvenile delinquent pursuant to the Federal Juvenile Delinquency Act, citation and sequential, after finding he had committed aggravated sexual abuse in violation of another two codes by knowingly using force to engage in a sex act with a juvenile. The case was in federal court because both Allen and the victim are Indians and because the incident took place within the Navajo Nation Indian Reserve in New Mexico. The district court placed Allen on probation until he reaches the age of 21 and required, among other things, completion of sex offender and substance abuse treatment at a youth facility. The only issue Allen raises on appeal is whether the trial court erred in finding the victim competent to testify. Allen states the test for determining the competency of a child witness is found in U.S. v. Spoon Hunter, 10th Circuit, 1973. In Spoon Hunter, this circuit applied the test for determining whether the competency of a child witness established by the Supreme Court in Wheeler v. United States in 1895. In that case, the court held competency depends on the capacity and intelligence of the child's appreciation of the difference between truth and falsehood, as well as the child's duty to tell the former. This determination was to be left primarily in the hands of trial courts. The court, however, warned trial courts to take care when excluding witnesses in order to avoid staying the hand of justice. Both Wheeler and Spoon Hunter, however, predate the enactment of Federal Rule of Evidence 601 and U.S. Code 3509 of Title 18. For this reason, the Wheeler test, this court has relied upon for years, no longer completely states the applicable standard for determining the competency of a child witness. Although it may inform many examinations taking place pursuant to this. So let's just talk about legislative development, maybe, as we can call it. Inform any examinations taking place pursuant to this section of U.S. Code and may help explain the type of evidence necessary to demonstrate a compelling reason for such an examination. We agree with the district court's conclusion that the evidence offered by Allen J. did not constitute a compelling reason to hold a 3509C competency examination. To counter the presumption favoring competency, Allen J. asserted the victim suffers mild mental retardation, possible due to fetal alcohol syndrome. So this is the witness's material facts, which caused her to repeat first grade. As the district court correctly pointed out, even if the victim only had the mental development of a much younger child, she would still be competent to testify. The evidence offered by Allen J. did not begin to show the victim had such severe problems that could not understand and answer simple questions or understand the difference between truth and falsehood and the consequences of falsehood and what was required by the oath. From Spoon Hunter. When the victim was called to testify, the court asked her a series of questions seeking to confirm she understood the importance of the oath. And oath. These questions included, do you understand what it is to tell the truth? And do you know the difference between the truth and the lie? The victim did not respond to the judge's questioning. The court then asked the prosecutor to try questioning the witness. The prosecutor began with simple questions. What is your last name? How old are you? And where do you live? Which the victim answered. After about 30 questions along these lines, almost all of which the victim was able to answer correctly, the prosecutor shifted to questions relating to the difference between truth and lies. Among other questions, the prosecutor asked the victim if she understood she had promised to tell the truth in court, to which the victim responded affirmatively. After these series of questions, which established the victim knew the difference between the truth and a lie, knew she was to tell the truth in court, and knew she would be punished if she told a lie, the court directed the prosecutor to proceed to hear to the heart of her case. Defendant's counsel objected repeatedly throughout this process and throughout the remainder of the victim's testimony. Allen essentially bases his appeal on several instances in the victim's testimony where she had difficulty answering questions. The victim did not respond to the trial court and trial judge's questioning. She gave the wrong answers to some. So counsel's questions. For example, she said she was 11 when she was 13, and she gave nonsensical answers to others. For example, she answered true to the question, is it good or bad to tell a lie? In addition, she apparently paused for long periods of time before answering some questions. Any inconsistencies in the victim's story or problems with her testimony, however, raise questions of credibility, not competence. Credibility, I beg to differ. The credibility of a witness is a question to be determined by the trier of fact, not this court. We find nothing in the record demonstrating the district court abused its discretion in permitting the victim in this case to testify. The decision of the district court is therefore affirmed. Okay, I lie. According to their definition of competence, that means allowed to testify, then this is a question of credibility and not competence. So there's one last section here called Victor Gold, Do the Federal Rules of Evidence Matter, from 1992, which is like an opinion. Some authorities have resurrected common law, mental and moral competency requirements in the guise of interpreting Rules 602 and 603. Some courts read 602 as imposing a mental capacity requirement, suggesting that witnesses lack personal knowledge unless they can comprehend their observations to an extent that makes their testimony trustworthy. Similarly, many courts establish a moral capacity requirement by concluding that the oath or affirmation requirement of Rule 603 cannot be satisfied unless the witness appreciates the nature of truth and the duty to tell the truth. On its face, Rule 602 does not justify excluding testimony on the ground that a witness lacks the mental capacity to make testimony trustworthy. The rule requires no more than the trier of fact that there is evidence sufficient to support a finding that the witness has personal knowledge. This standard should be satisfied if a reasonable juror or judge could believe that the witness perceived the matter testified to. Based on the rule standard, it is up to the jury, not the judge, to decide if the witness is trustworthy. Rule 603 likewise imposes no moral capacity requirement. The rule requires only that the witness perform the mechanical act of taking an oath or affirmation in a form calculated to, so this is 603, calculated to awaken the witness's conscience and impress on his or her mind with the legal duty to tell the truth. On its face, I'm just rereading. Rule 602 does not justify excluding testimony on the ground that the witness lacks the mental capacity to make testimony trustworthy. The rule requires no more than that the trier of fact find that there is evidence sufficient to support a finding that the witness has personal knowledge. So that's 602. Now, moving beyond 603, just read the definition. Nothing in the rule suggests that the witness must in fact have his or her conscience awakened and mind so impressed. A member of the advisory committee reports that the committee specifically considered and rejected imposition of any standard of moral qualification. Furthermore, in his testimony before Congress in support of Rule 601, the reporter for the federal rules made the point that the very precise presence of the oath or affirmation requirement in Rule 603 diminishes the need for competency evaluations of the sort conducted at common law. It is ironic, then, that Rule 603 has been turned into a vehicle for determining Rule 601's general statement that every witness is competent. So that's that for before we enter into dead man statutes. And that's everything I'm reading for Thursday.